incredible legal remedy to get any case dismissed in court. Greetings, my name is Signal Dodecahedron, and I'm going to read this report today. It's provided free of charge. This information in the following pages is being provided without charge. It is for your convenience only. We suggest you go to the links above to access the most current and up-to-date information ordered by this provider. The following pages may be subject to copyright. And what I have provided below this video in the description box is the files to direct download. Once again, free of charge. This is all free information, and it's up to you to practice it inside of the court. If you decide to, you don't have to file anything or become a secured party creditor as far as the filing, but you can actually ask 3 basic questions in open court. And we're going to read this report today and see if it's enlightening, but it's up to you to practice it. You have nothing to lose. If it doesn't work in court, then you're just going to continue with your regularly scheduled sentence. But here we go. Incredible legal remedy to get any case dismissed in court. Basic concepts. The person who creates the trust is a settlor. The person who holds the property for another's benefit is the trustee. The person who is benefited by the trust is the beneficiary, or cestui trust. The property that comprises the trust is the trust rests, meaning the property, the corpus, principal, or subject matter. For example, a parent signs over a certain stock to a bank to manage for a child with instructions to give the dividend checks to him each year until he becomes 21 years of age, at which time he is to receive all the stock. The parent is a settlor, the bank is a trustee, the stock is the trust rest, and the child is the beneficiary. The fiduciary relationships exist in the law of trust whenever the settlor relies on the trustee and places special confidence in her. The trustee must act in good faith with strict honesty and due regard to protect and serve the interests of the beneficiaries. The trustee also has a fiduciary relationship with the beneficiaries of the trust. The trust takes legal title to the trust rest. The trustee takes legal title to the trust rest, which means that the trustee's interest in the property appears to be one of complete ownership and possession, but the trustee does not have the right to receive any benefits from the property. The right of the benefit from the property, known as equitable title, belongs to the beneficiary. The terms of the trust are the duties and the powers of the trustee and the rights of the beneficiary conferred by the settlor when he created the trust. State statutes and court decisions govern the law of trust. The validity of a trust of real property is determined by the law of the state where the property is located. The law of the state, the permanent residence domicile of the settlor, frequently governs the trust of personal property, but courts also consider a number of factors, such as the intention of the settlor, the state where the settlor lives, the state where the trustee lives, and the location of the trust property, when deciding which state has the greatest interest in regulating the trust property. As a general rule, personal property can be held in a trust created orally. Express trust of real property, however, must be in writing to be enforced. When a person creates a trust in his will, the resulting testamentary trust will be valid only if the will itself conforms to the requirements of state law or wills. Some states have adopted all or part of the Uniform Probate Code, which governs both wills and testamentary trusts. What is a cestui trust? Pronounced cestui or cestui KV. And why should you care? In 1666 in London, during the Black Plague, the Great Fires of London, Parliament enacted an act behind closed doors called the Cestui KV Act, 1666. And there's a URL link right there. The act being debated, the Cestui Act, to subrogate the rights of men and women, meaning all men and women were declared dead, lost at sea, beyond the sea, and back then operating in admiralty, the law of the sea, so lost at sea. The state of London took custody of everybody and their property into a trust. The state became the trustee slash husband holding all the titles to the people and property until a living man comes back to reclaim those titles. He can also claim damages. Reclaim using UCC-1 financing statement for the United States of America and private property security agreement for Canada. The rule of the use of capital letters used in a name. When capital letters regarding used anywhere in a name, this always refers to legal entity, fiction, company, or corporation, no exceptions. For example, John Doe or Doe Jane, passport, driver's license, marriage certificate, and birth certificate. Sestake Trust, pronounced Sestake or Sestake, commonly known in New Zealand and Australia, or strawman, common term in the USA or Canada, is a legal entity, fiction, created and owned by the government. Whom created it, I repeat, owned by the government. Legally, we are considered to be a fiction, a concept or idea expressed as a name, a symbol. That legal person has no consciousness. It is a juristic person, ens legis, a name or word written on a piece of paper. This traces back to 1666. London is a state, just like the Vatican is a state, just like Washington, D.C. is a state, corporate states. The Crown is an unincorporated association. Why unincorporated? It's private. The Temple Bar is in London. Every lawyer called to the bar swears allegiance to the Temple Bar. You can't get called without swearing this allegiance. The Crown already owns North America and everything in it. Your only way out is to reclaim your dead entity, straw man, that the Crown created. Become the trustee of the Sestake Trust and remove yourself from the admiralty law that holds you in custody. The subrogation of your rights. When London burned, the subrogations of men's and women's rights occurred. The Responsible Act passed. CQV Act 1666 meant all men and women in the UK were declared dead and lost beyond the seas. The state took everybody and everybody's property into trust. The state takes control until a living man or woman comes back and claims their titles by proving they're alive, and claims for damages can be made. This is why you always need representation when involved in legal matters, because you're dead. Quote-unquote undead. The legal fiction is a construct on paper, in a state, in trust. When you get a bill or summons from court, it is always in capital letters, similar to tombstones and graveyards. Capital letters signify death. They are writing to the dead legal fiction. Legal fiction was created when someone informed the government that there was a new vessel in town based upon your birth. Birth certificates are issued at birth, just as ships are given birth certificates. Your mother has a birth canal, just like a ship. All this information relates to how the general public are still legally tied. Through admiralty law, through this ancient legal construct, we can be easily controlled. Learning about your legal fiction helps you unlock yourself. Otherwise, you're just a vessel floating on the sea of commerce. It is possible to be free from financial stress and debt. Parents are tricked into registering the birth of their babies. In about 1837, the Births, Deaths, and Marriages Act was formed in the UK. And the post of Registrar General was established. His job was to collect all the data from the churches which held the records of birth. Regis, from Queen or Crown, all people are seen to be in custody of the Crown. This allows people to function in commerce and to accept the benefits provided by the state. We are in custody worldwide under the IMF. The majority of people are fed, shelter provided. However, now it is the system that is benefiting while many are suffering. Are poorly fed, housed, and water is contaminated. Many people are now getting sick and dying as a result, not to mention that as people evolve, they now seek to be independent of any system that seeks to control or oppress and harms the earth that this is all taking place on. We have legally elected representatives. We have to understand who we are as men and women and how we can relate in the system. The City of London is a center for markets which merchants work. There is mercantile law. It comes from admiralty. Look at the symbols in the City of London that relate to admiralty. Our national banks are not our banks. The private shareholders from the private banks own the banks. It is all private, not public, as we are led to believe. Quote-unquote of also means without. For example, the bank without England. Private banks issue private currency. With World War I, a change happened. where money was not backed by gold or silver anymore. It is now based on people's labor. People are now pledged to the IMF as a surety to pay back the creditors in the global bankruptcy. Men and women are not bankrupt. They are the only source of credit. The public is bankrupt. Regarding the currency that gets issued at the Bank of England, people are the gold or the treasure. The government issues bonds or treasury bills that are bought by investors. The money goes back into the economy in order to pay for the people to build things, e.g., for example, an Olympic Stadium. However, the people are paying the taxes for the privilege of using someone else's currency and paying back the principal and the interest on the original loan that was given against the treasury bonds, bills, and notes. It is a private corporation that will own the Olympic Stadium, be responsible for running it, be able to sell commercial rights, yet the people are the actual ones who own it and should be profiting from it. However, principal and interest is coming through the people in order to raise the money. So where you have commerce and money, you also have quote-unquote justice. You need to understand the bankruptcy before you can understand the judiciary. You need to accept the bankruptcy. We have accepted the claim to accept the summons. There is also an obligation to accept any liability which has been created. All you can do is accept the bankruptcy. We are operating in admiralty. A not guilty plea dishonors the bankruptcy. The straw man, also known as legal fiction, is always guilty and needs to be accepted for value. Barristers and solicitors make a living out of creating controversy, and by creating a controversy, you become liable for the case. Honor and dishonor. To remain in honor, you have to accept the claim and settle it. Then you add conditions. I accept on proof of claim and proof of loss. This gives the liability back to them. Legal fiction is always guilty. Only in the high courts can the real man or woman appear. Games are played in courts, hence the name court is a game with actors acting on acts. It has to be treated as a game and just business. Courtroom dramas are misinformation. In the public, we are operating in bankruptcy and you receive benefits. It takes a lot of time, effort, and study to use these tools. You have to be prepared to go fully through the process. Get the right tool out of your toolbox at the right time. People need to learn how to act as creditors. In summary, money is backed by labor. We cannot exchange it fairly for gold and silver. Capitalization of a name means dead entity, a legal fiction. Know who you are. You are not your straw man or dead fictitious entity. Learn how to become a creditor in commerce. Here's some important links. All the best with this. Winston Shrout addresses Necessity Act Trust. An intro into the ideas of how your entity, strawman, all caps name was created. In 1666, an Act of Parliament created during the Black Plague of Great Fires of London behind closed doors was called the Cesta KV Act 1666. You can read the Act here. There's a link. The Act being debated was the Cesta K Act, which was to subrogate the rights of men and women, meaning all men and women were declared dead, lost at sea, beyond the sea. This was done during a crisis. The state took custody of everybody and their property into a trust. The Cesta Key Trust, the state became the trustee, husband, holding all the titles to the people and property until the living man comes back to reclaim those titles and can also claim damages. The Cesta Key Act or Trust created is an all-capitalized name, a dead entity who had all his belongings put into a trust. This act still exists and this trust still exists. This is how it started. The video is by Winston Shrout, Irene Gravenhorst, Jordan Maxwell, A Critical State. I'll speak about this subject. The basis of how bankers use the law to hijack an all-caps name that you didn't even know existed is briefly touched on in this 5-minute video. The intention is to give you a peek at the ideas from freedom-based videos. If you're born on Earth, if you have a birth certificate, this applies to you. The only way to claim your trust and to get free from admiralty laws is to understand who you really are, and that admiralty law doesn't apply to you. But in order to get free, you must do some homework, file forms, and know how commerce applies to you. Bam. Free your mind, change your world. Here we go. Court. Who's who and what to say. My position on going to court has always been never voluntary go to court. Live men and women are not meant to be in a place designed solely for business of fictional legal entities. When we attend court, we are deemed dead. In fact, they cannot deal with us until we admit to being dead. A legal fiction, a trust. Court is for titled persons, judge, prosecutor, defendant, bailiffs, cops, and attorneys. Live men and women are not recognized, so it makes sense to send in a dead person, an attorney, to handle our cases, except for one thing, that they don't know how this system works due to their indoctrination. If you can find one to do as you say, then you will prevail, but most of them would rather hang on to their bar carriage than behave honorably. The only thing that dead fictional legal entities want from us is our life, energy, and the only way they can get it is by our agreement. Without us, they cannot function, so they are desperate to get us into court to have us pay the debt which they created by charging the trust, which is your CQV, all capital letter name. Since common law courts no longer exist, we know that the case never has anything to do with the facts, or live men and women, and so anyone who testifies or talks about the facts of the case is doomed. All courts operate in trust law, based upon ecclesiastical canon law, ritualism, superstition, Satanism, etc. This manifests as insidious commercial law, and we are in court to take the hit if they can get us to do so. They use every trick in the book: intimidation, fear, threat, ridicule, rage, even recesses, in order to change the jurisdiction when they know they are losing, in order to make us admit that we're the name of the trust. When we do so, we are deemed to be the trustee, the one liable for administering the trust. Ergo, until now, it has been a waste of our time, energy, and emotion to go into a place where it is almost certain that we'll be stuck with a liability. We all know from our indoctrination, programming, and schooling that judges are impartial and have sworn an oath to this effect. This means he must not favor either the plaintiff or defendant, but our experience reveals that he does indeed favor the plaintiff, indicating a glaring conflict of interest, that the prosecutor, judge, and clerk all work for the state, the owner of the CQV trust. So as the case is not about justice, it must be about the administration of a trust. They all represent the trust owned by the state, and if we are a beneficiary, the only two positions left are trustee and executor. So if you detect the judge's partiality, although I doubt the case will go this far, you might just want to let them know you know this. If you consider court as entertainment, and if you can stand the evil emanating from its officers, the fear, angst, and oozing from the walls and the treacherous atmosphere, then go and knowing that under trust law we cannot be the trustee or executor of a trust whilst being beneficiary, as that would be a conflict. The position of beneficiary may lack clout, but the other positions hold liability. Since state employees want to be the beneficiary of the trust, the only way they can do so is to transfer to us the liability which they hold as trustees and executors, because they cannot be both the administrators and beneficiary of the trust. So trusteeship and executorship, that is suretyship, becomes a hot potato, and everyone wants to toss it so he or she can be beneficiary of the credit from the trust. When we were born, a trust called the Sesta KV Trust, CQV, was set up for our benefit. The evidence of this is the birth certificate. But what is the value which must be conveyed to the trust in order to create it? It was our right to property via birth into this world, our body via the live birth record, and our souls via baptism. Since the state and province which registered the trust as the owner, it is also the trustee, the one that it administers the trust. Since they also wanted to be beneficiary of this trust, they had to come up with ways to get us as beneficiary to authorize or charge in the trust, allegedly for our benefit via our signature on a document, citation, application, etc., and then temporarily transfer trusteeship to us during the brief time that they want to be the beneficiary of a particular constructive trust. This means that a trust can be established anywhere, any time, and the parties of the trust are quickly, albeit temporarily, put into place. But since a beneficiary cannot charge a trust, only a trustee can do so. It is the state that charges the trust, but they do so for their benefit, not ours, albeit occasionally we do reap some benefit from that charge, but nowhere near the value which they reap. Think bank loan. We reap a minute percentage of what they gain from our authorization. So the only way under trust law for them to be able to charge the trust is to get us to get the authorization from the beneficiary, us. The only way for them to benefit from the trust, or from their charge, is to get us to switch roles from beneficiary to trustee, the one responsible for the accounting. And for them to switch their role from trustee to beneficiary, because no party can be both at the same time, that is, within the same constructed trust, they must somehow trick us into accepting the role of trustee. Why would we do so when the trust is for our benefit, and how do they manage to do this? Well, the best way is to get us into court and trick us into unwittingly doing so. But if we know what has transpired prior to our being there, it is easy to know what to say so that this doesn't happen. The court clerk is the hotshot, even though it appears as if the judge is. The clerk is a trustee for the CQV, owned by the state, province, and it is she or he who is responsible for appointing the trustee and the executor of the constructed trust, that particular case. So she or he appoints the judge as trustee, the one to administer the trust, and appoints the prosecutor as executor of the trust. The executor is ultimately liable for the charge because she or he who brought the case in court and created a constructive trust on behalf of the state province which charged the CQB trust. Only an executive prosecutor can initiate and create a constructive trust. We all know the maxim of law. Whoever creates the controversy holds the liability, and whoever holds the liability must provide the remedy. This is why all attorneys are mandated to bring their checkbooks to court, because if it all goes wrong for them, meaning either they fail to transfer liability onto the alleged defendant, or the alleged defendant does not accept their offer of liability, and someone has to credit the trust account in order to offset the debt, since the prosecutor is the one who issues bogus papers and charges the trust. It is the prosecutor executor who is in the hot seat. Now, here we go for the main questions that you ask in open court, and you must ask this politely. Just interject right when the hearing starts. When the name of the trust, for example, John Doe, is called by the judge, aka administrator, aka trustee, we can stand and ask, are you saying that the trust which you are now administrating is the John Doe Trust? Or for another example, you use your name in all caps. You just ask aloud, are you saying that the trust which you're now administrating is the Joshua Gutierrez Trust? Or are you saying that the trust which you're now administrating is the Mary Simpson Trust? Just replace John Doe with your actual all capital letter name. And just ask a question like that. And so, this establishes that we know the name is a trust and not a live man. What's the JAT's first question with Judge, Administrator, Trustee? What's your name? State your name for the record. We must be very careful not to identify with the name of the trust, because doing so makes us the trustee. What does this tell you about the judge? If we know that the judge is the trustee, then we also know that the judge is the name, but only for that particular constructed trust. Now think about all the times that the Jats have become so frustrated by our refusal to admit to being the name that they issue a warrant, then as soon as the man leaves, he's arrested. How idiotic is that? They must feel foolish for saying that John Doe is not in the court, so I'm issuing a warrant for his arrest. And then the man who they just admitted is not there and is arrested because he is there. Their desperation makes them insane. They must get us to admit to being the name or they pay, and we must not accept their coercion or we pay. Because the JAT is the trustee, a precarious position, the best thing to say in that case, John Doe is indeed in the court. You point to the judge, and it is you as trustee. You are John Doe today, aren't you? And you would replace John Doe or Jane Doe with your all-cap name. Now, during their frustration over not admitting to being a trust name, the trustee or executor of the trust, we had to ask who they are. Before we go any further, I need to know who you are. Address the clerk of the court, the trustee for the CQB trust owned by the state province. Are you the CQB's trustee who has appointed this judge as administrator and trustee of the constructive trust case? And you would say your case number. Did you also appoint the prosecutor as executor of this trust? Now, in open court, they can't lie. So the clerk of court would confirm, and then you would point to the judge. So you are the trustee, and then you would point to the prosecutor, and you are the executor. And then you would announce, and I am the beneficiary. So now we know who's who, and as beneficiary, I authorize you to handle the accounting and dissolve this constructive trust. I now claim my body, so I am collapsing the CQB trust which you have charged, as there is no value in it. You have committed fraud against all laws. Likely we will not get that far before the judge will order a case dismissed, or even more likely, the prosecutor, as he clings tightly to his checkbook, will call, "We withdraw the charges." It says that's basically what will possibly happen, or the judge will run out of the courtroom and the prosecutor will withdraw the charges, or they would just discontinue having the fraud exposed and remove you from the courtroom, and in a couple days you should get the charges dropped and processed. Let's continue reading here. We have exposed the fraud of the CQV trust, which exists only on presumptions. The CQV has no corpus, no property, or no value. Trusts are created only upon the conveyance of property and can exist only as long as there is value in the trust, but there is no value in the CQV trust, yet they continue to charge the trust. that is fraud. The alleged property is we, men and women, who they've deemed to be incompetent, dead, abandoned, lost, bankrupts, or minors. But that is an illusion, so if we claim our body, then we can collapse the presumption that the trust has value. They're operating fraud, something we've always known. But now we know how they do it. Our having exposed their fraud gives them only three options. One, they can dissolve the CQV trust. The one for the clerk of the court is a trustee and from which he or created the constructive trust, which is the case for which he or she is appointed the judge and prosecutor, titles which hold temporary liability, trustee and executor respectively, but they cannot dissolve the CQV, or the entire global system will collapse because they cannot exist without our energy, which they obtain via that CQV trust. Two, they can enforce the existing rules of trust law, which means as trustee they can set off their debt and leave us alone. Now they know that we're onto their fraud, and every time they go into court to administer a trust account, they will not know if we are the one who will send them to jail. The trustee judge is the liable party who will go to jail, and the executor, the prosecutor, is the one who enforces this. This is why they want us to take on both titles, because then not only do we go to jail, but also by signing their paper, we become executor and enforce our own sentence. They cannot afford to violate the ecclesiastical canon laws out of fear of ending their careers, so they are, again, trapped with no place to run. Three, they can dismiss the cases before they even take the risk of our exposing their fraud, which also makes no sense because then their careers again come to a screeching halt. What's a court clerk to do? Pretty soon none of these thugs will take any cases because the risk is too great. This will be the end of the court system. Knowledge, not procedure, is power. Yes, and then the rest of this report continues to go into the history of the Vatican, the Unum Sanctum, and all this. So you can actually download the rest of this report, the full report, in my description box below this video. So hopefully you enjoy this little presentation. This is just information. It has nothing to do with legal advice or what. It's just ask some simple questions in court. You got nothing to lose. If it doesn't work, you're just going to go with your continually, regularly scheduled sentence. Just continue with what they're going to throw at you anyways. So you have a chance to get your case dismissed by exposing this strange Sesta KV trust fraud, which is your name in all capital letters, also known as the straw man, transmitting utility, fictitious entity, person, legal fiction, ens legis, capitis diminutum maxima. Yeah, it's pretty strange, but if this shit is true, then it should work for you, so just test it out. This is free. If it works, spread the word like the air we breathe. This is Mr. Signal Dodecahedron. Thank you.